Good afternoon and welcome to today's presentation. My name is Beth Overmo. I'm the Strategic Plan Coordinator for the State Bar, and I just want to give a couple of housekeeping items before we get started with today's presentation. First of all, the presentations typically last about 40 minutes with time for Q&A at the end. How our attendees are able to ask questions is through the questions or chat taskbar provided by GoToWebinar. So if you were to type your question into the chat pane on the control panel, you can send your questions at any time, but just know that based on the amount of time the presentation takes, we will either take questions at the end, which I will relay to the presenter, or we will compile all questions and the presenter will answer them following the conclusion of the presentation, just in case we do go over on time. And with those housekeeping items in place, I'm going to turn it over to Laura Hensley to introduce today's presenter.
Thank you, Nicole. Today's presenter is, I'm used to calling him Director Marsh, but it's James Marsh, the former director of the Department of the Division of Labor and Management. James retired in 2017, much to my dismay, as the director of the Division of Labor and Management for the South Dakota Department of Labor and Regulation after 30 years of state service. He is now the owner of J.E. Marsh Consulting, which provides consultation on all aspects of South Dakota employment laws and alternative dispute resolution services, including arbitration, mediation, and officiating local and state government hearings. James graduated from the University of South Dakota Law School in 1986 and received his bachelor's degree, summa cum laude, from Dakota Wesleyan University in 1983. Personally, I've had a lot of experience with Director Marsh during his years at the department, and he was an invaluable resource that is greatly missed and still a source of information and knowledge for all of us. And I specialize in this field, and I still go to him often. So with that, Director, I will turn it over to you.
All right, thank you, Laura. Appreciate the kudos. I'm not always sure what was happening in the last 30 years, but I'll accept your version of it. How about that? We're going to move through kind of a mix of advanced and simple stuff. I'm not sure what kind of audience I have today, but I'm going to try to keep it as painless as possible. I'm going to keep things simple. I make references to various cases in the slides I provide just by a name of a person, and generally the site is the focus, so it's not blue book stuff, but at least there'll be enough to get you where you need to go. It isn't a comprehensive list of cases, but it is enough to kind of open the door. So if you're able to go in on your own and look at those and review those, that will help you, I think. But in any case, I'll start with a grain of salt. Your malpractice carrier probably won't accept, but Marsh said is an excuse for lack of due diligence. So make sure you follow up on your own. Thank you. All right, what are we going to cover today? General principles of workers' comp law, some basic DLR procedures we follow, because I'm still a part-time employee with the department, kind of on a consulting basis. Still keep in touch with them and can give you some information in that regard, and resources you can use to try to help you work through workers' compensation claims as you represent either insurers or claimants. Starts with a great compromise. We always refer to it as the deal, perhaps. Workers' compensation is a no-fault employer-funded injury insurance, which was used to substitute for employer liability laws that would emerge at the beginning of the century. The trade-off is employers get the insurance, but in the alternative, they are not sued. It's workers' comp is an exclusive remedy. If you look at 62.311, you'll see that uninsured employers are not fined or penalized or enjoined from operation simply because they're uninsured. The only remedy, if they do not have the insurance, is that someone gets hurt on the job, they can sue in circuit court for either negligence or twice workers' compensation indemnity and medicals in no fault. So it's either a fault-based action and good old negligence claim or an indemnity claim for no fault. There are various ways in which insurers can or employers can be covered. They can be insured under a DLR authorized comp insurance company. They can be self-insured by applying for it with DLR. There is a certificate that has to be issued with that. So if they don't have the certificate, they're not self-insured. And some of our very largest employers live under the belief that they are self-insured when in fact they're not. Usually what goes on there is they have an insurance company with a gigantic deductible attached to it, so that for all practical purposes, they are paying their own freight. But they aren't necessarily aware of that. Government agencies just pay their own freight like self-insureds do. A lot of times they go through pools like the municipal league or the school board association pool. What I want to convey is that no other combination of insurance invokes that exclusive remedy. We have a lot of employers out there who think that because they've got occupational illness or disease coverage or injury coverage, that somehow exonerates them. If they have health insurance, none of those things are going to do. It's not going to prevent this employer from being sued for being uninsured. An employer simply want to use the service of another for pay. Under 6212 in the Carpenter case, Carpenter versus a Rapid City Red Dogs case, they have acknowledged clearly you have to have a quid pro quo relationship. I pay you, you work for me, that's employment. And we also have what we call a statutory employer. We have a general contractor that has a sub doing business for them. The sub has employees, but the sub has no insurance. The employee can bypass the sub, the uninsured sub, and go after the general contractor on the project for benefits. Again, though, if the contractor has insurance, it's not a lawsuit, it's a workers' compensation claim. The employee, in turn, is the one who provides those services. There are people who are considered statutory employees. Volunteers for government agencies, including firefighters and rescue workers, are considered employees just by virtue of that. Not everybody who claims to be a firefighter is, so you can use the Woodcock case as a basis for figuring out whether they've legitimately signed up or not. It does not include independent contractors, and I won't burden you with the infinite number of tests for that. Suffice it to say, if you look at the Agemo case at 470 Northwest 2nd, you'll find those tests laid out in agonizing detail, and you can sort them through. An injury, in order to be covered, must arise out of and in the course of employment. I cite for you the Voller case because it's fairly instructive in that regard. There are two standards, whether the injury arises out of the employment and whether it's in the course of employment. In the Voller case, we had somebody who was shot in a parking lot and by an estranged husband. And essentially, there wasn't any real argument over the in the course of part of the test. In the course of refers, generally speaking, is it on the clock? And for purposes of that, it was a lunch break, and they were going to extend that clock or expand it so that that person was considered on the clock at the time. Where it failed was the arising out of part of the test. There was no increased risk for this person connected with their employment that caused them to be shot. Basically, that was something personal, completely separate from the work, and as a result, workers' compensation didn't cover it. So both of those tests have to be met initially, just to establish whether something is work-related. And there are a multitude of carve-outs and expansions that go way beyond the scope of what we're talking about here that you'll need to pursue on their own. An injury must also be a major contributing cause for a workers' compensation's medical condition and or disability. Under the Orth case, kind of the standard, clear standard there, it must be established by objective medical opinion. I don't know how many calls I get from workers' compensation claimants who say, well, I didn't have these problems before, now I do, so isn't it work-related? Well, it makes some sense, and it's certainly something a doctor needs to know. But unless the doctor renders an objective medical opinion saying, yeah, I think there's a connection here, a requisite connection, and I know what's going on, major contributing cause is not established. As a rule of thumb, the Orth case says that there can be no greater cause than the work injury for it to be a major contributing cause for the condition. So baseline, black and white rule, if 50% of the problem is work related, it's enough. And it doesn't have to be 50% plus, it's just 50% so that no greater cause than the work injury contributes to the problem. The last injurious exposure rule still applies, has for 40 years. If the worker had a pre-existing condition caused by a compensable work injury, the new injury need only independently contribute to it in order for it to qualify. So we have 2 injuries to the knee, for example, one happening on the job 15 years ago, one happening 5 minutes ago. As long as the doctor feels that the new injury added something, however slight, to that previous injury, then it's still work-related. Now, it is possible that you can return to a baseline, that sort of aggravation happens, time passes, and that new contribution is gone. And then you go back to baseline, you go back to the previous injury. But until that happens, the new employer and the new insurance company pick up the tab. Selected coverage issue, I thought this would be of interest, and as much as coronavirus is all the talk these days, there is such a thing as a workers' compensation occupational disease claim, but it has to be peculiar to the employment and due to hazards in excess of ordinary employment. Now, we've had issues with this in the past concerning, HIV and other bloodborne pathogens. We've had it with, anything from smallpox to rabies to you name it. But it has to have a peculiar occupational aspect in order for work comp to pick it up as a disease. The simplest version is, do you claim work comp for a cold? No, unless you happen to be in an environment where that cold is part of the world in which you live. You are a nurse or a researcher or an epidemiologist who deals with these things on a daily basis and thereby obtain a special risk to incur them. So for the factory worker who happens to get coronavirus, pretty unlikely they're going to be able to make a claim. A healthcare worker, or such as the doctor who passed away from COVID, yeah, they have a more legitimate claim in my view. There are various bases for denying a workers' compensation claim or excluding it, which we need to walk through. There is the agricultural exemption, which is explicated pretty well in the Hofer versus Redstone Foods case. And I mentioned the Stone case for you because many times I get questions from practitioners saying, well, it's the ag exemption, so can I still sue these guys? And the answer under Stone is, yeah, you can, but you have to be able to show negligence or, with all the requisite defenses, such as assumption of the risk and contributory negligence, in order to be able to establish the claim. I mentioned intentional tort, not because I think anybody's ever going to have a shot at it, honestly, but because it's there. If you have an intentional tort, it's not covered by workers' compensation. In my 30 years of practice, I have as yet to see a successful intentional tort claim, and then along these lines. And the window for that is growing narrower with each decision that comes out. So don't count on it. The standard denial is based on the fact that the employee has 3 business days to notify the employer of their claim. The latest gold standard in that regard is the McNeil case. I paraphrase it as, when did the employee know there was an injury, that I got hurt, that it was possibly work-related, and that it was serious enough to report? And by serious enough to report, I mean, should they have seen a doctor? Should they have started losing time from work? And it's based, under the McNeil case, on a reasonable person's understanding, given their education and intelligence. More basis for denial would be for misconduct. That's been a kind of a hot topic in the last 5-10 years. The employer has the burden of proof in that regard, and it must be established that the misconduct is a proximate cause of the injury. The example I usually give groups is what I call the wrecking ball scenario. If I have somebody who's stoned on whatever, and they're driving through a construction zone and they get hit by a wrecking ball, it doesn't really matter how stoned they are, unless you can establish somehow that if they weren't stoned, they wouldn't have been injured anyway. If they're injured regardless, you haven't established that the misconduct is a proximate cause of the problem. But using that standard, the types of misconduct that have been recognized are for intoxication, use of Schedule 1 or 2 drugs. I note the Goebel case for you because in that case, Goebel was denied benefits, whereas Ben Steenwick was granted benefits, even though it was very clear that he'd been using pot clear up to the day of injury. Failure to use employer-provided safety devices or follow safety rules. Rather than paraphrase it, I encourage you to take a very good look at the Holscher versus Valley Queen Cheese case because it beats out that particular drum in agonizing detail. Compare the Wells case where it was involved a ground fault interrupter, and the person was supposed to hold the device in his hand, did not, was electrocuted, but still received benefits, even though they were strongly told by the employer that they needed to have it. just for the record, where the Wells case fell off the wagon was that the electrocution could not be established to be connected to the fact that the person didn't have the device in their hand. So it was still considered a compensable claim. Deliberate acts constituting more than ordinary negligence. In the Cantaloupe case, it was not found to be more than ordinary negligence, even though it was an asthmatic who was smoking on the job constantly. In the case of horseplay, where there's just goofing around on the job and somebody gets hurt, basically, the Petrick case, I think, has narrowed the window of likelihood of success in those cases to almost nothing. I don't know how the horseplay defense survives after Petrick was decided. Statutes of limitation, of course, freshman year of law school, we all know you better know your SOLs before you go into a workers' compensation matter. For a work comp, it is, first of all, 2 years after both the department and the claimant receive written notice of a denial. So once the agency gets it, claimant gets it, 2 years go by, it's an absolute bar to benefits unless a petition for hearing is filed. 3 years after the last payment of benefits, unless the claimant shows a change of condition. By benefits, they mean either disability benefits or medicals. When that tap stops, 3 years go by, the claim is closed, unless it could be shown that a change of condition occurs. Change of condition requires showing of bettering or a worsening of a person's physical condition for which the injury remains a major contributing cause. So in order to be able to do that, you're going to have to go back to the doctor and establish whether some changes occurred. Even if benefits were paid, the statute of limitation occurring first among the 2-year and the 3-year laws is the one that's applied. So first in, first out in both the Faircloth case and the Thurman case. All right, assuming we've got a legit claim, then we're taking a look at the types of benefits that are paid. For disability benefits, those are based on earnings. Usually what the worker grossed in the year before the injury from all jobs worked, okay, everything. And that has evolved from the old days when you only looked at the work the person was injured at. Now it's everything. Overtime hours are considered at straight time pay, and there is an imputed wage for certain public workers such as firefighters, ambulance drivers, and rescue workers. And there is this weird special formula that's used for other government volunteers besides those folks, which you'll just want to take a look at and evaluate. You then convert the earnings to average weekly wages under the statutes that are listed. The two main questions you want to sort through in that regard are, first of all, was the person employed the entire previous year at that job? Or maybe their grade changed. Maybe they went from, say, Inspector 1 to Inspector 2. If there was a change in grade like that, you only base the earnings on that period in which they had made that changed position. Also consider seasonal employment. Now, seasonal has a fairly limited definition, which you find in the Jackson case. It's not so much that a person works for certain months of the year, say, but that the work they are doing is truly considered seasonal. The difference between, for example, a construction worker who works construction all year long, but maybe or could work all year long, but maybe only works 3 to 4 or 5 months a year, versus a groundskeeper for a golf course. I mean, let's face it, grass only grows for 5 or 6 months around here. So that would be a more seasonal job. Benefit rates are almost always set on the date of injury. In fact, one of the critical things I'd leave with you, if nothing else, if you're fairly new to workers' comp, always know what the law was on the July 1st before this person got injured, between that July 1st and the next one. Because whatever law there was at that time is like the terms of the insurance policy for that person, and though you're only following those rules. Finally, for disability, the waiting period is 7 days of at least partial incapacitation in order for benefits to be paid. Okay, so assuming we break disability benefits into two types, temporary and permanent. For a temporary total, when a person is totally off work by doctor order, the starting point is that they receive 2/3 of their gross wages during the time that they're working, during the time that they're off work, rather. Well, it's 0.6667 of that average weekly wage, technically, but that's the rule of thumb, 2/3. The maximum benefit right now for them is $829 a week, so it is capped. There are minimums too, which we can talk about later if you feel a strange urge to do so. There's also a temporary partial benefit, which is spelled out a little bit in the Hendricks case from the 1990s. Basically, when a person is released to work light duty, you take a look at the average earnings they receive after their release, compare them to the pre-existing average weekly wage, and split the difference, divide it by 2. As a backstop, both that temporary partial and the wage have to add up to at least what that person would have gotten for temporary total benefits. And in general, temporary total and temporary partial benefits stop when this person is fully back to work or has been impairment rated. Now, this is sometimes causes a certain confusion among practitioners out there, because the person continues to lose time from work after they're rated. Does that have any meaning? Well, for probably 90% of cases, not really. If they lose time from work and they are not eligible for something more than permanent partial, that income loss doesn't translate into anything, at least in itself. That leads us to permanent partial disability. We have a schedule for that. I mean, it's very cut and dried. There is no difference, in essence, between what a piano player and a lawyer would receive for the same injury. All you look at is whether that person has a body part that was impaired in a measurable way into the guides, and if there is a rating that can be associated with that. If there's a rating, you pay the permanent benefit based on the body part affected, the impairment rating that was given, and the temporary total rate that person receives. Just a very quick math. Let's say we've got an arm that rates 200 weeks of benefits of being lost. If it's lost, clear up to the shoulder. Okay. The impairment, let's say, is 10%, and the wage rate is $1. Okay. The comp rate is $1. If you do that, then you say the 200 weeks for the arm times a 10% for the rating times $1 gives you $20. That's what their permanent partial disability rating is, regardless of whether they're back to work or not. Okay. On the other hand, permanent total disability works more like it has an impact in terms of wage loss. It is lifetime temporary total with a COLA. It is automatic if 2 or something is lost. And by 2 of something, I mean, consider the eye, the ear, the arm, the leg. If more than one of those is lost in any combination, let's say an eye and a leg, it is an automatic perm total. In the Dudley case, it was a loss of sight in both eyes. Otherwise, look at the age, training, physical condition, work available in the worker's community. It has to be able to prove it on the claimant's part. It has to be obvious because of chronic pain. The doctor or others say, wow, this person is in so much pain that not only can they not function right now, but if they were to go back to work, it might even make it worse. Okay? Or they are unemployable according to medical and vocational experts. Not an obvious pain case, not that bad, but still that person's circumstances are such that they can't make temporary total at any bona fide job, even with accommodations. And on the Scheid case it's cited, the example was given and it was pretty cut and dry. This person had a comp rate of $370 a week, and they were able to return to work, which made $360. Okay, but because they couldn't return to $370, they were still perm total. They were released to work full time. Could work some duty during that full time, but it wasn't enough. They were still perm total. Can't be retrained for an additional job. That was that law was amended several years back after a Supreme Court decision, and the Bayer decision talks about that aspect of it. It can be a single job that they return to. In McLaughlin, we had somebody who had a job handing out boots at Morrell's. Okay, and in that case, they said because that job was needed by Morrell's, it was a regular job that they could create, that he was going to be paid at least his temporary total rate to do it. That was a sufficient job to obviate the responsibility for paying work comp. The claimant does need to do a job search in these cases that are not obvious. A vocational expert opinion on the reasonableness of that job search, however, we don't need an expert weighing in on whether somebody did a good job of a job search. All we need to know is that they did it, and it's up to the fact finder, the judge, to take a look at that job search by the claimant if they go on their own and figure out whether it's adequate. There are also death claims in workers' compensation. You don't see them very often. We get about 10 death claims a year and almost never contested. But I would just let you know in fact, there's a whole page on the department's website where it kind of walks you through how death benefits work, and it might be worth checking that out. In any case, I'll just give you a couple of sketches. Survivors get temporary total, and by that I mean first the spouse, if there is one, Second, the kids, both custodial and non-custodial. They must be dependent on the claimant at the time the person was injured, not necessarily the date they died. In the Sopco case, the difference in years was decades, literally. But because the person did not have those dependents on the date of their injury, those dependents were not eligible to for benefits. And there is a scholarship program for South Dakota post-secondary schools for any dependent, including the spouse, of a workers' compensation decedent. Okay, medicals. Medicals are 70% of the costs workers' compensation pays. So naturally, many of the calls and concerns we get are in connection with those. The employee has a choice of physician. Employee can acquiesce in that choice, however. Let's say the employer decides to send this employee to a doctor for something beyond emergency care. If the employee acquiesces in the plan that that doctor establishes, that becomes their employee's choice in our view. There is no change then in that chosen doctor, whether by acquiescence or direct choice, without written approval from the carrier. But if the employer refuses to make treatment available, the employee can in some cases just go looking for it. Look, you have an obligation as an insurer to pay for my reasonable medical care. You aren't doing it, so I'm going to go find it wherever I need it. The insurer is not liable for any resulting aggravation when a claimant unreasonably refuses or neglects treatment. It is not necessarily, denial of all medicals, of course, just those medicals that occur from the point of unreasonable refusal forward. There's a balancing test in those cases where we take a look at the probable benefit to the employee of some kind of care versus the kind of risk they obtain as a result of undergoing it. And if one outweighs the other, very utilitarian thing, then workers' comp is in a position of saying if your condition was aggravated for the refusal, benefits don't have to be paid. And there is a fee schedule for workers' comp, which is set out in agonizing detail. If you need to know particulars about amounts and protocols of the fee schedule, is contact the department. They're the ones that created the rules for that and can work through it with you. It's only for necessary, proper and reasonable care. What a treating doctor says goes, unless it's proven wrong. There is a difference, however, between necessity and convenience of care. In one case, they talked about a television set just being a convenience in a hospital room versus a necessity. In the Howie case, it was a spa that was connected to the house. It was found that if the person had to travel to a different town to get their hydrotherapy, they lost the benefits of it, and there was no contesting medical information otherwise. So it was found that building the spa within the house as an addition was actually a necessary medical cost. As of 1993, all workers' compensation carriers are required to have medical case management provisions in their insurance policies. In our view, it doesn't mean they have to use them, but it does mean that if they are going to engage in some kind of utilization review of employees' medical care, that they should go through that authorized plan to do it, except, of course, in the case of an independent medical examination. When they meet those requirements, they can use the IME as a basis for reviewing the care. The employee has to attend if requested, if demanded, if you will, or their benefits will be suspended. Of course, it begs the question, if the employee doesn't have any benefits, if they've already been denied, what leverage does the insurance company have to make them go? And the answer is not much. Now, the IME does not have to be followed up on if it is inconvenient. It is not reasonably convenient for the employee. There is no clear definition of what that term means, but we have taken the view that if it is physically appropriate, if it's not going to make this person worse, then they should be able to attend. Now, lately, apparently there have been some department decisions that have talked about the fact that if you're shipping somebody off to New York State for something that's a claim here that's kind of that for which the treatment or the examination could be done more locally, is that really convenient for the employee? And the answer remains somewhat questionable. I would say I would encourage you to try to go local if you can on the part of the insurance company. And now it just says in the note, no more than once a month, but the actual law says the first IME can be done on the date of injury, the next one within a week or so, and the last one, the third exam, if you will, can be done on a monthly basis after that. It has to be done by a South Dakota licensed practitioner as a practical matter. It is not so much a requirement of an independent medical examination to do so, but If an employee refuses to attend an exam that's not being conducted by a South Dakota licensed practitioner, there's no implications there. We have held repeatedly that benefits cannot be suspended because the law has not been satisfied. Some additional issues that have come up recently in terms of subrogation. Know that other forms of insurance have to pay under whatever policy provisions they have when workers' compensation denies it. In fact, in the one of the Bertelsen cases there cited for you was found to be bad faith on the part of another insurance company being aware of this law to deny a claim because they felt it was a workers' compensation matter. In calculating the subrogation interests involved and by money and what share is belonging to the parties involved, I encourage you to take a look at the ZOS cases. They actually lay out in a table the form in which those subrogation interests have to be considered, including the payment of fees. And where medical costs were covered by a health insurer, subrogation only covers the amount actually paid as opposed to the amount charged. So it's important to keep that straight. The Department of Labor approves all attorney's fees. Under the Stanton case, it outlines the general requirements for that, but there is also a law that says that an attorney can only receive 25% of a settled amount that doesn't go to a hearing, an amount of 25% of the amount the attorney obtains through their efforts, 30% of an award after hearing or a circuit court appeal, and 35% of a Supreme Court appeal. It can be paid in a lump sum or in a present value. For subrogated claims, when the claimant's attorney does the work of obtaining this action against a third party and then comes back and has to deal with subrogation issues later, the attorney can deduct up to 35% from the subrogated claim. And the same thing works, by the way, for insurance companies' attorneys. If they're the ones who initiate the third party action and the claimant gets the benefit of the gravy, so to speak, that attorney can take up to a 35% deduction from the recovery. For lump sums, benefits and to be paid in the future can be totally or partially commuted. There is no discount for payments that have already been accrued, and attorney's fees can be lump summed. If you need the information, the rule to do it is Greek. I couldn't do it on my own. The Department of Labor has Excel spreadsheets that they can use to calculate those lump sums on request. In the case of perm totals specifically, lump sums are disfavored, and it seems as if the last 2 or 3 decisions coming out of the courts have made them less and less favored. It has to be shown that there's an exceptional financial need arising from reduced income due to an injury or necessary to pay an attorney. It's made with the goal of continuing that income stream for that permanently totally disabled person as long as possible. Okay, to the department, what role do they play in all this? Well, first of all, an employer has 7 days to report their injury to its insurance company, or if it's self-insured, they report it to us. There's a $100 fine if they don't. An insurer has 10 days to forward that report to us or be fined. And direct relevance, an insurer has 20 days to investigate the claim, which they can extend up to 50 initially, or they are in turn fined by the department. As for notification requirements, the insurer, when they issue the denial, must do that in writing, and they must describe the bases for which they denied claim. Now, there's a 10% penalty for benefits more than 10 days past due. The critical part of that, however, is it must be without a good faith dispute about benefits. Just because it's late doesn't mean it's their responsibility. It must also show they have no real basis for it. The Department of Labor must award attorney's fees, may award attorney's fees in cases in which benefits were unreasonably or vexatiously denied. So ordinarily, the prevailing party in a workers' comp claim doesn't get their attorney's fees paid. But basically, if the insurance company cannot show a basis for having done what they did in denying the claim, the department can award fees as a punishment. In dispute resolution in general, the Department of Labor does offer informal assistance to anyone who asks. If you want to call me, I'll consider it, unless you want to go into some great detail in the matter. I will accept those calls and essentially bill them to the department, or you can speak to one of the other folks at the agency for information. We conduct mediations still on a pretty regular basis. I'm doing most of them these days, but I'm going to hand over the torch to that eventually once the staff gets up to speed. They're mostly telephonic, but we can do in-persons if the issues are sufficiently complicated and we need to be able to sit down and look at the paper and process those. They're confidential. They're very quickly scheduled. A mediation can be scheduled within a couple of weeks, and very effective. Our settlement rate with those runs about 85%. In hearings, those are initiated by a petition for hearing form. I believe we have a shell available on the DLR webpage for that, but if not, there is an administrative rule that sets out the requirements for the petition and that you can follow to establish your own. Those hearings these days are all being done by either Michelle Faw or Joe Thronson in the office, doing a real good job. I don't want to get much into bad faith because this is a presentation in itself. So I've only discussed the very basics of that. It's a circuit court action, not a Department of Labor action. It's a first party tort claim. Workers' compensation bad faith differs from that type of claim in general because no contractual relationship exists between the insurer and the claimant. The claimant has to show an absence of a reasonable basis for a denial of benefits, an insurer's knowledge or reckless disregard of the lack of that basis as a denial basis. The reasonableness is viewed at the time the insurer made the decision to deny or litigate the claim rather than pay it. And an insurer's unreasonable conduct, for all intents and purposes, in itself, if we're not talking about the act of denying or not denying, but their conduct in general as it relates to the claimant is considered irrelevant. It's adversarial, and that's okay. Some selected procedure points. The evidentiary requirements in our hearings are very relaxed. Civil procedure rules don't apply unless an administrative law judge adopts them. But discovery procedures, they are becoming very complex these days, and there are sanctions for non-compliance with those. So a great many of the days of our judges' time are spent sorting through motions to compel, whether or not interrogatories were correctly worded, whether they asked for too much or too little, those types of things. So just be prepared if you're going into that practice to get some paperwork done. All right, finally, some resources for you. Westlaw has a substantial number of the Department of Labor's decisions available. The Department of Labor has posted most of its decisions, including declaratory rulings, written since 2000. A declaratory ruling being an agency holding that is held out in general, is supposed to guide the department in future actions. The Department of Labor will provide its claim file to an attorney representing a claimant, an insurer, or employer. The cost is $20 a claim. Doesn't matter, but also if you have 8 claims that are a page apiece, it's $160. If it's one claim that's 50,000 pages, it's $20. So it's per claim. Hearing files are public information unless they're ordered to be sealed by the judge. Some of the things you'll find in the Department of Labor file are, first of all, the injury form, showing the date, the nature of injury, addresses, treating physician. Both the employer and the claimant complete that form. The 107 form is the one that shows what monthly payments were made by category, sometimes valuable to know. The 110 form shows how temporary total was calculated and the wage information used as the basis for it. The 111 form shows permanent partial disability calculations with a physician rating report attached to it. The insurer is again required to deny things in writing, so we have a copy of the denial letter with the basis for it. And sometimes there's correspondence, medical reports, and lump sum requests included. Okay, I just provided a slide with the contact information for the agency. If you have specific questions about workers' compensation coverage, policy, premiums, that sort of thing, that's more a matter for the Division of Insurance than us. And finally, if you have questions for me, feel free to contact me. I'm out there. I'm still in the game, just not as active as I would have been in the past. So I'm certainly eager to hear your questions. All right, that's it. I appreciate you listening in. I'll open her up for questions.
All right, so James, it looks like we have 2 questions in the queue currently.
Okay.
The first question is, if a worker is seasonal, are temporary benefits only paid during the season they would work?
Oh, no, the benefit is a completely separate matter. The only issue concerning seasonal is figuring the amount, because it's done by a different formula than it is other types of benefits or the other types of claims. Here, we'll make that. Whoop, sorry. Here we go. Now, if the person does have to show, however, that not only are they off work because they have an injury, but because basically that's the only reason they're having their time off. So if they're saying, well, you would have been back to work, let's say they're released to work, light duty, and that person, would have been back to work, but for the fact that, well, they're just off for a while, then there's kind of an open question about whether or not they really should be receiving benefits or not. And the other question.
The second question is, can you discuss the impact of the coronavirus on entitlement of temporary total disability, such as in the case where there are company closures or layoffs where restrictions had been accommodated?
Okay. Then again, the two parts that you have to consider, first of all, are they actually experiencing an income loss because of their injury? Or in this case, might be arguably an occupational disease. Okay. If they are not experiencing an occupational disease, if they are off work, they have the coronavirus, and that is then a completely separate issue over whether, let's say they hurt their back and then they get the coronavirus on the side. Okay. The coronavirus, it would then have to be evaluated as the ultimate reason why they're off work. We had cases, for example, where the person injured their back or their neck, and then then they had a heart attack. Okay. In those cases, we said the heart attack took over, if you will. And the same thing would probably apply in the case of a coronavirus. The person is discouraged from returning to work. So the question becomes, are they off work because they had a bad back, or they do that because they have coronavirus? And unless the coronavirus is an occupational disease, I would say workers' compensation probably isn't responsible for it, unless they can show that for the back injury, say, by itself, that the person should be is not able to return to work. Now, if a coronavirus is an occupational disease, that's a different kettle of fish, because, I mean, we're receiving these notices that say, we should not be getting these people back in where they can infect other people. And if that's the case, you can make a pretty strong argument that the reason they're off work is because they were exposed to coronavirus instead of something else. So they probably should be receiving disability benefits during that period.
So it looks like there's a follow-up to that question. So what if the employee doesn't have coronavirus, they have a shoulder injury, had been work light duty, now the employer shuts down to prevent the spread of the virus, it's unrelated to the injury?
Okay. Well, it is said in the temporary partial law that 6245 that the employer has to have bona fide job offers available for their employees in order to be able to relieve themselves of their obligation to pay benefits. In this case, when they don't have any such work out there, the presumption is going to be that that person starts receiving benefits, in as much as they have a shoulder injury already. They'll be losing some time from work, and the question then becomes, well, are they able to work somewhere else? If the employer is going to walk away from that one as far as establishing a liability goes, then they're going to need to find some other job that this person can do within their restrictions. On a temporary basis, it's almost not worth the effort, if it's not going to go on for very long. So.
All right, well, it looks like we have no other questions in the queue. I don't know if, James, if you have any final thoughts, or Laura, if you have any questions.
Okay, I do have a question, or maybe a few. So what we run into a lot is just the person walking along and they fall. There's no hazard.
Mm-hmm.
Is that covered? I mean, we see that very often, and it's probably it is the top call I get, I guess, as a practicing attorney in this field. So what is your position on that? There's someone that's just literally just walking. Yes, mm-hmm. They're at work, but they walk, trip, fall, hurt themselves.
Yeah.
What is your position
on
that?
I think our position has solidified in light of the Voller case that I mentioned earlier, because they do refer in the Voller case to an increased risk that occurs in the workplace that leads to the injury. Okay. So in that case, unless you can show there was something about the work environment that person was in that caused that kind of increased risk over what you'd see anywhere on the planet, they're probably not going to be covered. Now, As you know, however, things change if, let's say, the person slips and falls on a carpet, and down they go, and then they hit a table or a doorknob, or they're up on a catwalk and they slip and fall and land on the ground. Ouch! Where that additional factor changes things, because then you do have something that the workplace has contributed, so that the injury becomes more likely to have arisen from the employment. But just a garden variety person is walking down the sidewalk, boom, or down an aisle, boom, and there's no way of knowing what, if anything, happened to them to cause it. Those things under the increased risk doctrine in Bowler probably aren't covered.
I agree with you, but that's not what some of the decisions have been. So that's why I am asking the question. And I just wanted to see if I was missing something. And it was interesting what you said about the horseplay defense being, I mean, essentially with Petrick, it's your position, I understand then, that horseplay really is not a defense after the Petrick case. Is that fair?
Not that I can see. I mean, goodness, these guys are running around. The Petrick case involved two guys are running around during a break. And the one decides just for a laugh, he's going to hurdle over a ditch that was a known hazard. He doesn't make it. He doesn't clear the ditch and breaks his ankle or sprains it. And they considered that a work injury. And the fact that they were screwing around, they didn't seem to matter. In fact, it was almost like the courts were saying, well, boys will be boys. They're going to do that. So good luck. And I thought, wow, if that gets covered, I don't know what does. I really don't. And of course, we have the Phillips case where the person actually got stabbed in the leg by a butcher knife, entry and exit.
Yeah, John Morrell. Yeah.
They're screwing around too. And they said, oh, well, because everybody was watching and didn't do anything about it, then suddenly this became a work claim. So yeah, I think the horseplay defense is, the paddles are out, and we're going to have to see if it gets resuscitated.
What about then, like with major contributing cause, you were discussing some of the language associated with the Orth case, that it has to be, that case, that it's a cause that cannot be exceeded. And you said, at least 50% of it, and no cause can be greater than that. What about in the situation when you have three causes? So let's say smoking, I'm making that number up, it's never that high, but smoking is 33% of the reason. For someone's degenerative back condition, maybe my genetics are 33 1/3, and my work injury is 33 1/3. What is your position on that?
Yeah, we've had to revisit that a little bit because apparently there was a circuit court opinion that came out a month or two ago, something like that, where they repudiated the department's position, saying, well, it should be at least 50% of the problem compared to everything else. In that case, the judge felt it was sufficient if you had multiple causes and the departments and there was no greater cause comparatively to each individual one. So let's say you had one that was 40%, and the injury was 40%, the other two were 30. Okay, because the 40% is greater than the 30s, or at least the same as the 30s. So I guess you could have three. They were all equally the problem, a third, and a third. Okay. If you had that, then work comp should pay because there is no greater cause individually than the work comp one.
How do you juxtapose that with Orth?
Well, I think, well, from what I gathered from the judge's comments, that they felt like we overread Orth. And maybe there's something to it. I know there was always kind of we debated for, well, I guess it's been about 15 years now since Orth came out, whether or not that was the right way to go. We didn't know. But I will say, ultimately, the rule of liberal construction applies to all benefit issues like that. And I'd almost have to think if push comes to shove, that's where they're going to go. That they're not going. That an appellate court would not disagree with a circuit court on that point. That they would say, yeah, because of liberal construction, you got to say there's no greater individual cause, so that means there's no greater cause.
And it looks like we have another question in the queue.
Yeah.
If an employee is hurt driving to a doctor's appointment for a work injury, are the injuries from the motor vehicle accident covered?
In my view, yes, because that benefit is extended. In fact, I'll take it a little bit farther. We did have an incident in the Supreme Court's decisions from the Johnson case in the 1980s, in which a person was performing what they call dual purpose. They were doing something work-related and something not work-related, and driving mail to the post office in the morning, and got in a car accident. And the Supreme Court said, as long as the work comp purpose had something to do with it, it was enough for work comp to pay. So in a situation like that, where clearly the person would not have been in the car where they were, except for the fact that they were going to a doctor's appointment, work comp's probably going to pick that one up. Again, you're dealing with issues potentially of, I don't know, gross negligence. You could say, I mean, they can't hurt themselves on purpose. They can't get drunk while they're driving the car. But if it's just, I'm going to a doctor's visit, that visit was precipitated by my work injury, that's probably all on the tab. Yep.
And it looks like we have another question as to ORTH question. So if 9 non-work causes are 10% each and the work cause is 10%, is it compensable? 90% total non-work versus 10% work injury. Still covered?
That's our view. Yeah, or at least that's the circuit judge's view.
All right. Well, it looks like we have no further questions in the queue. Laura, did you have any other questions?
I could probably sit there and ask questions all day, and I don't want to bore James with that. He knows that I'll probably call him afterwards and do it anyway. So no, I don't have any additional ones. I was anxious to hear the opinion on the last, especially the last ORTH question. That's interesting to me, that because I don't understand then in that situation which ones, how everything wouldn't be compensable. If it's 10% is enough as opposed to everything else. That's an interesting.
Yeah, and it's a difference of degree. If the work comp injury is 9% of the problem and the other 10 are all 10, the work comp claim isn't compensable, at least as I understand the view of the judge, because there are greater causes than work individually.
And so your understanding of the reading is it has to be compared to each individual cause, not the work-related cause versus every other unrelated, non-work related.
That differs from what we did as a department for 20 years. So we stood up and took notice of that one too.
So we were able to give our audience a little time to think of another question. So isn't it a but-for analysis? In other words, if the person was able to work before the 10% cause of injury occurred, it would be compensable.
Well, the ORTH rationale, talking about major contributing cause, applies to both medical treatment and the disability that results from a claimed injury. Either half of that equation, it depends on what you're looking at. If you're looking at, do you pay a medical bill because this person was 9% injured at one claim and 10% at everything else? Well, I mean, no. But if it's 10% for work comp and 10% for everything else, then yeah, work comp pays. Keep in mind, in that regard, we've got the Mettler case versus Sibco, where a woman experienced endometriosis and also had a work comp injury to her back. The endometriosis symptoms were expressed as back pain. And so they did some diagnostic tests trying to figure out what's going on with Ms. Mettler, and it was determined, well, she's got endometriosis. That was treated, and she also ended up having ongoing back pain. So she submitted the back claim, the expense of the testing to the insurance company, and was ultimately held to be, the insurance company was ultimately held to be liable for it. So in some cases, I guess the reason I throw that one out is because intuition doesn't always serve in this field. Sometimes you have to look at it being kind of a cut and dried liberal construction. Either we connected the dots or we didn't kind of analysis, as opposed to something else.
All right, and there are no further questions in the queue. So James, if you have any final thoughts or remarks, I'll let you close with those now.
All right, well, I appreciate that. I give you my picture from Trip Lake as my first slide because I want to remind people that no matter what happens with this craziness going on lately, that the world still keeps revolving and we still keep trying to do our jobs. And I hope I can help you do yours. So thanks.
Absolutely. Thank you, James and Laura, and thank you everyone for attending today's webinar. If you have any other questions, please feel free to either send them along to me at elizabeth.overmont@sdbar.net or to James directly. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you'd complete that and provide your feedback. You'll also receive a follow-up email within 24 to 48 hours with a link to view a recording of today's webinar. So on behalf of the State Bar of South Dakota and our presenters, thank you for joining us today, and we hope you stay safe and healthy and enjoy the rest of your week.
Yeah, thank you very much for putting this together.